3, 2, 1, start. It would be necessary to first deal with the objection of availability of an alternative remedy to the petitioner. Stop. It is settled law that mere existence of an alternative remedy does not oust the jurisdiction of the writ court. Stop. In view of the decision of the Honorable Supreme Court reported in 1998, 8 SCC 1 within bracket Whirlpool Corporation versus Registrar of Trademarks, Mumbai bracket close, at least in 4 situations, a court of writ would be justified in entertaining a writ petitioner despite availability of an alternative remedy. Stop. One of such situations is when the action impugned in the writ petition is violative of the principles of natural justice. Stop. The rule of exhaustion of alternative remedy, being a rule of desertion rather than a rule of compulsion, in an appropriate case, the court would be justified in exercising its discretion. Stop. Having regard to the facts and circumstances of the present case, in my view, since the issue of violation of the principles of natural justice is involved in the instant lease, the petitioner can certainly approach the Honorable Writ Court notwithstanding the availability of an alternative remedy. Stop. I therefore do not propose to relegate the petitioners to the alternative remedy. Stop. Mr. Mojumdar placed reliance upon an unreported judgment delivered by this Honorable Court in WP number 3375 within bracket W of 2013, wherein it had, inter alia, been observed that the power exercised under Article 226 being much wider in nature, revision under the rules cannot be considered to be an efficacious remedy. Stop para. A perusal of the record reveals that at the juncture of issuance of the charge sheet to the petitioner, the authority decided to hold the inquiry and named the inquiry officer on the body of the charge sheet and fixed the date of inquiry with the stipulation that the inquiry will be conducted ex parte, if the petitioner fails to attend the inquiry proceedings. Stop. Such action is ex facie derogatory to the Railway Board's circular dated 31/1/2003 as quoted in paragraph 9 of the writ application, but such averment had not been controverted by the respondents as would be explicit from the contents of paragraph 5 within bracket E of the affidavit in opposition. Stop. From these facts, it appears that the concerned authority acted in a biased manner and with a closed mind, not that the charges are baseless, but the mind of the authority was somewhat predetermined. Stop para. A perusal of the statements made by the witnesses before the inquiry officer reveals inter alia that there existed a dispute as to whether the theft at all took place during the camping duty period of the petitioner and as to whether the steel crossing slippers recovered were a part of the consignment. Stop. The PW1 admitted that he had no basic knowledge about making joint note and that the same was prepared by A.K. Singh in his own handwriting and that he had only put his signature. Stop. The PW2 in course of his examination had stated that the 17 steel slippers which were recovered were a different size, and such statement does not establish the contention to the effect that the said recovered steel slippers were a part of the consignment. Stop. From the deposition of PW3 within bracket A.K. Singh, it appears that according to him, theft took place on 2/1/2006, but according to PW1, the theft was not current of 5th January, 2006, it might have occurred 2 by 3 days ago, and as per version of the keyman, the slippers were intact up to the evening of 4th January, 2006, and such contradictory statements do not establish that the theft took place during the camping duty period of the petitioner. Stop para. In the inquiry report, it further stands recorded that in reply to question number 20, PW3 stated that as per statement of arrested accused persons and the theft report, it is presumed that the recovered materials are the part consignment of Kunuri. Stop para. The contradictions as discussed above had not been taken into consideration, and it appears that the inquiry officer had proceeded on the basis of a presumption that the recovered materials were a part of the consignment. Stop. The finding to the effect that the theft had occasioned during the camping duty of the petitioner does not stand supported through the evidence on record. Stop. The contradictions in the evidence were pointed out in the defense statement, but the same had not been dealt with in the inquiry report, and the inquiry officer had abruptly concluded the inquiry report, stating that upon summing up of the evidence on record, the charges stands proved against the petitioner. Stop para. From the inquiry report, it is explicit that the concerned officer had merely recorded his ipse dixit that the charges were proved without assigning any reason why the evidence produced by the management appealed to him in preference to the evidence produced by the petitioner. Stop. The expression sufficiency of evidence postulates existence of some evidence which links the charged officer with the misconduct alleged against him. Stop.